The European, the, oh, sorry. Welcome on behalf of EADH, the European Association of Lawyers for Democracy and World Human Rights. The EADH is a lawyers organization with members in 22 European countries, from Ireland to Russia, from Sweden to Turkey. All of us work pro bono. I mentioned this just because it limits our resources and our activities. Our activities are not limited to Europe, but concern any part of the world. My name is Thomas Schmidt. I'm a trade union lawyer from Düsseldorf in Germany, and together with my colleague Shirin Ünsal, I'm co-secretary general of ELDH. ELDH defends human rights, the rule of law, democracy, the rights to self-determination. We support victims of human rights violations, political prisoners, refugees. We organize conferences, webinars, and networks. We observe trials like the Julian Assange trial, many trials in Turkey, trials in Greece and Hungary and Spain. We visit prisoners, in particular in Turkey. We support and organize fact-finding missions. We write reports and statements. We send our observations to the respective governments and to international institutions and bodies. We cooperate with many other national and international lawyers organizations in the world. We cooperate with the European and international human rights institutions like the UN Special Rapporteurs, such as the Social Special Rapporteur on Arbitrary Detention, on the situation of human rights defenders, on the independence of judges and lawyers. So I don't have to explain why the case of Julian Assange is of high relevance for us. It is so important that we decided to organize a series of seminars to analyze the case and to discuss how the extradition to the USA can be prevented. Anyone who has not yet read the book of Julian Assange by Nils Melzer, UN Special Rapporteur on Torture and Other Cruel, Inhuman and Degrading or Punishment, or I have to add, of course, he is former Special Rapporteur, he can read or she can read the very revealing details about political motivated justice. Therefore, I want to thank today's speakers for sharing their knowledge and experience with us, as well as other participants. Thank you very much.
Thank you, Thomas. Welcome everybody again, and thank you, Thomas, for that helpful introduction to the ELDH. Very grateful that the ELDH is co-hosting this meeting, or rather hosting this meeting along with the various groups around the world who are inviting their members to join us. I'd also like to give a special shout out to my students from the University of Reading who are also here, many of whom are joining to try and understand various issues around whistleblowing and human rights. Our first speaker is a hugely respected scholar, a hugely respected lawyer. Marjorie Cohn has lectured and written extensively about the case of Julian Assange. She's written for Truthout. She's Dean of the People's Academy of International Law. She's Professor of Law Emerita at the Thomas Jefferson School of Law, former President of the National Lawyers Guild, and a member of the Bureau of the International Association of Democratic Lawyers. She's also the US representative to the Continental Advisory Council of the Association of American Jurists. Marjorie, it's such a pleasure to have you here. Thank you so much for speaking on this panel. Over to you.
Marjorie, you are muted.
I was muted. Okay, yes. I wanted to thank Deepa and all who organized and are participating in this really important, critical program in this case, which is undergoing at this point as we speak, a very, very significant and I would say frightening development, and that is the hearing in the UK High Court. The indictment against Julian Assange is based on WikiLeaks' 2010 to 2011 exposure of war crimes on a massive and unprecedented scale committed by the United States in Iraq, Afghanistan, and Guantanamo Bay. The indictment has nothing to do with Hillary Clinton and the 2016 election or the Swedish allegations of sexual misconduct that have been dropped. So what did WikiLeaks reveal that is at the heart of the indictment against Julian Assange? Well, first, the Iraq war logs, 400,000 field reports, including 15,000 unreported deaths of Iraqi civilians, as well as the systematic rape, torture, and murder after U.S. forces handed over detainees to a notorious Iraqi torture squad. They revealed the Afghan war diary, 90,000 reports of more civilian casualties by coalition forces than the U.S. military had reported. And they revealed the Guantanamo files, 779 secret reports with evidence that 150 innocent people had been held at Guantanamo for years, and 800 men and boys had been tortured and abused in violation of the Geneva Conventions and the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment. WikiLeaks also revealed the notorious 2007 collateral murder video, in which a U.S. Army Apache attack helicopter targets and kills 11 unarmed civilians, including 2 Reuters journalists and a man who came to rescue the wounded. 2 children were injured. That video contains evidence of war crimes under the Geneva Conventions. WikiLeaks also exposed Cablegate, 251,000 confidential U.S. State Department cables that disclosed corruption, diplomatic scandals, and spy affairs on an international scale. According to the New York Times, they told the unvarnished story of how the government makes its biggest decisions, the decisions that cost the country most heavily in lives and money. The Obama administration, which prosecuted more whistleblowers under the Espionage Act than all prior U.S. administrations combined, considered prosecuting Assange, but they were concerned it would violate the First Amendment to the U.S. Constitution. They were unable to distinguish what WikiLeaks did from what the New York Times and The Guardian did, since they also published documents that Chelsea Manning had leaked. The Trump administration, however, did indict Julian Assange in 2018, and it became public in 2019. Assange is charged with violations of the Espionage Act and the Computer Fraud and Abuse Act. He faces 175 years in prison if extradited to the United States, tried and convicted. The UK arrested Assange and is holding him in Belmarsh prison pending a decision on whether he should be extradited to the US to stand trial. He has been in the top security Belmarsh prison in London for 5 years. An investigation by Niels Melzer, former special rapporteur on torture and other cruel, inhuman, or degrading treatment or punishment, concluded that Assange suffered prolonged exposure to psychological torture during his confinement in Britain. In January 2021, a UK district court judge denied extradition after finding that Assange's mental health was so frail there was a substantial risk of suicide if he was extradited to the United States because of the harsh conditions of confinement in which he would be held there. But the judge rejected all of the other legal objections to extradition that were raised by Assange. After the district court had already ruled, the US came forward with so-called diplomatic assurances that Assange would be treated humanely if he was extradited to the United States. The UK High Court of Justice said it was satisfied with the Biden administration's conditional assurances that Assange would not be subject to onerous special administrative measures that would keep him in extreme isolation and monitor his confidential communications with his attorneys, that he would not be housed at the notorious ADX Florence maximum security prison in Colorado, that he would receive psychological and clinical treatment in custody, and that he could serve any custodial sentence in Australia, notwithstanding the fact that the United States has reneged on prior such assurances and that they can be taken back if someone in the Board of Prisons decides to take them back with no due process and no accountability. Nevertheless, as a result of these so-called U.S. assurances, in December 2021, the High Court reversed the District Court's denial of extradition, and the Home Secretary ordered extradition. In November of 2022, the New York Times, The Guardian, Le Monde, Der Spiegel, and El País signed a joint open letter calling on the Biden administration to drop the Espionage Act charges against Julian Assange. They wrote in that letter, "Publishing is not a crime," and noted that Assange is the first publisher to be charged under the Espionage Act for revealing government secrets. The charges in the indictment allege that the revelations of WikiLeaks harm national security. But those revelations contain evidence of U.S. war crimes, which the U.S. government seeks to hide from the public. The indictment would punish conduct that national security journalists routinely engage in, including cultivating and communicating confidentially with sources, soliciting information from them, shielding their identities from disclosure, and publishing classified information. If Julian Assange is prosecuted and convicted, it will chill journalists both in the United States and abroad from publishing evidence of government wrongdoing. The First Amendment to the U.S. Constitution allows journalists to publish material that was illegally obtained by a third person if it is a matter of public concern. No publisher has ever been prosecuted under the Espionage Act for disclosing government secrets. The U.S. government has never prosecuted a publisher for publishing classified information, which constitutes an essential tool of investigative journalism. But rather than dropping Trump's case against Assange, consistent with the position of the Obama-Biden administration, Joe Biden has zealously pursued extradition and prosecution of Julian Assange. In the two-day hearing held on February 20th and 21st before two judges on the UK High Court, Assange's lawyers asked the court to allow them to appeal issues that the UK District Court judge had rejected without full consideration. These issues include, first, Article 4, Sub 1 of the US-UK extradition treaty does not allow extradition for political offenses. Espionage is a classic political offense, and the prosecution of Assange is politically motivated. Assange's legal team wrote, "The gravamen and defining legal characteristic of each of the charges is thus an alleged intention to obtain or disclose U.S. state secrets in a manner that was damaging to the security of the U.S. state. That makes them political offenses." The defense claims it was an abuse of process for the United States to pursue extradition of Assange for a political offense. The United States is arguing that the Extradition Act does not contain an explicit exception for political offenses, but the defense says that the political offense exclusion is an age-old prohibition found in virtually every UK extradition treaty. It is included in UK treaties with 156 out of 158 countries. But since it isn't included in the Extradition Act specifically, the district judge did not fully consider that issue. Second, Article 7 of the European Convention on Human Rights says, "No one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under national or international law at the time when it was committed." Julian Assange could not have been reasonably expected to know that he could be prosecuted for publishing in the public interest because no one has been prosecuted for publishing in the public interest before. Journalists had never before been prosecuted under the Espionage Act. The third appellate issue that Julian Assange's legal team raised is that Article 10 of the European Convention on Human Rights protects freedom of expression. That includes the right to receive and impart information and ideas without interference by public authority and regardless of frontiers. The information that WikiLeaks revealed was true, and whistleblower Chelsea Manning was acting in good faith and in the public interest when she provided it to WikiLeaks. Extradition, Assange's lawyers argued, would constitute a flagrant denial of Assange's right to freedom of expression, particularly because he might be denied the protection of the First Amendment. 4, disproportionate penalty. Assange is facing 175 years in prison if he is convicted. But the extradition treaty between the US and the UK would allow the United States to amend or add charges which could expose Julian Assange to the death penalty, a punishment prohibited in the UK. Fifth, Article 6 of the European Convention guarantees the right to a fair trial. It will be very difficult for Assange to get a fair trial if he is extradited to the United States. The prosecutor, as well as former US CIA Director Mike Pompeo, said that as a non-US citizen, Assange has no First Amendment rights, which would prejudice him at trial in the United States. He would be prosecuted in a federal court in the Eastern District of Virginia, a conservative court where the jury pool will be drawn from people connected to the US government, national security agencies, and contractors. And Assange would not be allowed to mount a public interest defense. Sixth appeal point, Articles 2 and 3 of the European Convention protect the right to life and the right to be free from torture or inhuman or degrading treatment, respectively. Evidence emerged after Assange's extradition hearing in the district court that the CIA had drawn up plans to kidnap and assassinate Assange, which indicates that he will likely be subject to inhuman and degrading treatment if extradited to the United States. And number 7, Article 4, Sub 3 of the extradition treaty forbids extradition if the request is politically motivated and not in good faith. Assange's lawyers wrote that this prosecution is motivated by matters other than the proper and usual pursuit of criminal justice. It is motivated instead by a concerted intent to destroy or inhibit the publishers of evidence of state criminal ability and thereby put a stop to the process of investigating, prosecuting, and preventing such international crimes in the future. Assange's lawyers argued to the judges on the High Court that although WikiLeaks revelations occurred in 2010 to 2011, Assange wasn't indicted until 2018 to 2019. That was because WikiLeaks revealed CIA spying tools in 2017 known as Vault 7. That infuriated CIA's Trump's CIA director, Mike Pompeo, who denounced WikiLeaks as a hostile, non-state intelligence service, which would allow them to take action without the knowledge of the US Congress. Government officials drew up plans to kidnap and/or Assange, and Trump himself specifically asked for those plans. And then the US government initiated the prosecution of Assange to cover up its plan for the extraordinary rendition of Assange, even though WikiLeaks wasn't the first to reveal the diplomatic cables. Actually, Cryptome.org published them first. An extraordinary rendition means when someone is basically snatched and sent to another country without legal process, where he or she would face likely treatment, torture, or cruel, inhuman, or degrading treatment. When considering whether the prosecution was politically motivated, the district judge didn't seem concerned about why 6 years had passed before Assange was indicted. Moreover, the defense points out, WikiLeaks revelations actually saved lives. These were the most important revelations of criminal US state behavior in history, Assange attorney Mark Summers argued to the High Court judges. The collateral murder video is the most important revelation since Abu Ghraib, Summers said. And of course, he was referring to the horrific torture photographs coming out of the notorious Abu Ghraib prison in Iraq. The cables Assange published disclosed extrajudicial assassinations, rendition, torture, dark prisons, and drone killings, Summers added. He called the Guantanamo files a colossal criminal act. After WikiLeaks published evidence of Iraqi torture centers that the US had established, the US government, the Iraqi government, refused Barack Obama's request to grant immunity to US forces who committed criminal and civil offenses there. As a result, Obama had to withdraw US troops from Iraq. That is a stunning result of those WikiLeaks revelations. No case poses a greater threat to investigative journalism than the Trump and Biden administration's pursuit of Julian Assange. Thank you.
Thank you, Marjorie. Thank you so much for that helpful introduction that really set the scene. For those of you who've just joined, I want to welcome you again. We have just heard from Professor Marjorie Cohn, who's given us the road here and explained how things have got here. During the course of this meeting, you will next hear from me about the 2 days of the hearings that we've just had, and thereafter we will go to my esteemed colleague, Professor Mats Andenas, who will talk about international law and the word way forward. I want to acknowledge right now our very helpful colleague from Haldane, the Haldane Society of Socialist Lawyers in the UK, my fellow co-vice chair, Liam Welsh, who's letting you into the room. And I want to say how grateful I am that Liam's helping with the coordination in the background. My name is Deepa Driver. I'm an academic and trade unionist teaching at the University of Reading. And for the last 5 odd years, I have served as the legal observer in the case of Julian Assange, covering both the procedural hearings as well as the actual substantive hearings. And during this time, I'm not sure if you can see me. Can I just check if everybody can see me? Marjorie, will you give me a thumbs up if you can? Thank you. During this time, what has really bothered me is the fact that our justice system doesn't seem to be working in the way I imagined it would. And what I would like to share with you today are my thoughts in relation to what are the kinds of things you would expect to see in a justice system that is well functioning in a country with the rule of law and where things are working okay, versus the kind of system we see in countries that we hold up and say, hey, this is really a dictatorial state, or one that really doesn't have the rule of law. One of the fundamental things we look for is access and open justice. That means that a range of things, including being able to access the hearings for both members of the public and journalists and others, to be able to access the hearings effectively, and to be able to put, in some ways, the judges on notice that the world is watching. This helps to keep the justice system honest, and those of you who are lawyers are very familiar with this. But one of the challenges we've had in the Assange case right from the start has been that access to court has been incredibly difficult. I've had to queue, for example, sometimes at 3 a.m. in the morning in order to be able to get into court to just monitor a hearing. And this is the kind of behavior we see in repressive regimes. And the issues in relation to such open justice and access issues have not just affected me as an individual, they have affected, for example, at the Old Bailey in the previous stage, 40 accredited NGOs who had been told they would have access to court were denied access on the day of the hearing, which meant that the coverage of this case is rather weak. It is now good that the mainstream media are starting to pay attention, but it is really important that those of you who are in this room make an effort to make sure that the media are asked questions about this case, because that might encourage them to come into the courtroom, but it also makes sure that our justice system is more robust. At the recent hearings, we've had access issues in that people didn't know right until maybe a day before the hearing that they had access. And this kind of issue was started by the fact that in previous hearings, remote access has been permitted, especially during the COVID period, for accredited journalists. But at this hearing, what happened was, even if you were a journalist, an accredited journalist, you were not allowed access unless you were in England and Wales. Now, most people who are interested in this case span, of course, there's a global interest, but there are some key pockets. For example, in Australia, Julian Assange is an Australian citizen, and people in his home country are very motivated, as is now the parliament, who have passed a vote with a 2/3 majority to bring Julian home. In the US as well, many journalists are deeply interested because a First World War relic, the Espionage Act, is being used to persecute a journalist. And so people are really interested in how the public interest is taken into account, because you don't have a public interest defense within the Espionage Act. So the fact that if you're an American journalist or an Australian journalist, you can only have remote access if you are within the jurisdiction of England and Wales. And this is the first time this restriction of the jurisdiction of England and Wales has been used, has been quite an unusual feature. So there are many politicians, for example, who came all the way to London and then received remote access, or others who were told you can't have access. The process within the court itself in terms of access was relatively smoother than it was in previous rounds of this, where there has been active intimidation. For example, a colleague from Reporters Without Borders and I were intimidated outside the court by the police, who threatened to arrest us for queuing to go into the public gallery because they were trying to misuse COVID-related regulations in order to prevent access to the court. And so that kind of issue wasn't experienced at these hearings, which is, the kind of despicable behavior we see in some of the really worst places. But on the other hand, within the court itself, there were many times when there was a main court, which was a relatively small courtroom. It was not one of the biggest courtrooms that were there, despite all the international interest. There was an overflow courtroom as well, but the overflow courtroom received information via video feed, which meant that if the video feed was cut off, which was done several times, or if you were having remote access and you had video access and you couldn't hear anything, then you couldn't really understand what was going on in court. So open justice was an issue, as was the fact that Mr. Assange was unable to attend his hearing. For the first time in a long time, he has been permitted to attend his hearing, but it has been reported, and I can't independently verify this, that he has a broken rib as a result of coughing severely due to an infection which he suffered earlier. And now he's obviously the long-term effects of torture, as Professor Niels Melzer, the former UN Special Rapporteur on torture, pointed out in his many reports when he was the Special Rapporteur. The long-term effects of torture on the system are unknown. Mr. Assange is known to suffer from depression, and Mr. Assange also has other chronic health problems, which mean that he also suffered a stroke in 2022, a mini stroke. So all of these mean that access is already an issue. And in the past, he has been forced to sit in a glass dock. When he travels from the prison to the court, as is in a maximum security prison, he is internally searched and, searched, put in what somebody described as an upright coffin, and moved from the court to here, from the prison to here. There have also been reports which in the past, as well as more recently, in relation to potential concerns about judicial impartiality. As far as I could see in the courtroom, the judges engaged with the hearing and appeared to be interested in the arguments that both sides made. That said, given the increasing public attention on the case, one would expect that, and the kind of dismissive attitudes that we've seen in the past, where a judge in the original case, I remember when he was first brought into the court, having been torn out of asylum, the judge asked him his name and his date, his age, etc., and then pronounced that he was a narcissist without any indication of that from discussions with him. So that kind of behavior was fortunately not present in the last 2 days of hearings. At the hearings, the defense made a real effort to share a range of things. I'm not going to go into the substantive arguments unless people want to ask about them in the Q&A, but I will just highlight some of the key ones. They talked about how the charges relate to some of the most important revelations in history, as Marjorie's already covered this within the appellate grounds. And while discussing this, I think it's worth reminding everyone that the US has had a history of US exceptionalism, of being unwilling to be accountable for its crimes. And this is not specific to the Assange case, whether it is the genocides in Southeast Asia, its role in Latin America in engineering regime change, supporting Pinochet's regime in Chile, which engaged in mass murder, engaging in, of course, the illegal war in Iraq that Julian Assange and WikiLeaks revealed, but also the aftermath of that in terms of the war on terror, not to mention the support of those who engage in lawless ethnic cleansing or genocidal behavior that continues. And all of this shows an unbroken line, for me at least, as an external observer, of systematized brutalization and othering, which is, of course, relevant to the way in which there is the commission of war crimes, serious and material war crimes, systematic war crimes, and the intention or the efforts to silence any criticism of those war crimes, including through processes in the court in earlier stages where, for example, victims of torture have given testimony and their testimony has not been seen as requiring either or noting the admission of that ever happening. So these are quite interesting things to have seen. There's also evidence, of course, of the US pressuring those who are on the ICC, who have sought investigations into them, into not investigating them. So given this context, it's very interesting to see how they've gone after a publisher and journalist. One of the things that the defense was really concerned about was that the reformulation, one of the assurances that the US has given has been about, the way in which the charges have been framed is that, oh, perhaps you will not be at the, you will not be facing 175 years is what the prosecution has argued. But even the expert witnesses have largely said that it is likely that the sentence that Mr. Assange receives, and this was before even the recent Schulte hearing, that is in excess of his natural life. So while there is discussion of the death penalty, which was over the last 2 days, I think it's worth remembering that being entombed alive under what are called special administrative measures, also known as the darkest corner of the earth, in the words of the Center for Constitutional Rights, is that Mr. Assange will not have, will be in a cell where he is in an 8x6 cell and moved in a 3-person hold. He will be in his cell 23 hours a day in a concrete bunker, and he will have no contact with his family except 2 15-minute phone calls a month. So the kind of what he might experience is pretty serious. On top of this, his defense lawyers talked about the potential reformulation of charges, which might actually create the potential for the death penalty to be applied if he were to be extradited to the US. They also talked about the Eastern District of Virginia being the home of the various intelligence agencies, and therefore friends and family in the jury pool largely being from those who are close to the intelligence community and therefore deeply opposed to the kinds of revelations that Mr. Assange did, including, which this was the bit which was most interesting about the defense piece, I think, to some extent, which was they laid out a timeline of how the Vault 7 leaks, for those of you who don't know about them, these relate to how the CIA can, spy on you through your microwave or through your television. And this was really important in riling and upsetting the intelligence community. And while they had been, the Americans, while they had made very many aggressive statements, the seriousness with which they approached Mr. Assange really increased with the Vault 7 releases, followed by the Pompeo statement that Marjorie referred to, and the subsequent actions, including extraction from the embassy. For those of you who don't know, there's been a recent case of Joshua Schulte, who has been under special administrative measures now for several years and who is in a dreadful state. He's the alleged whistleblower for Vault 7 to WikiLeaks, and he has been given a sentence of over 30 years. So it's, which is, of course, I'm sure his lawyers will be contesting, but for the time being, he is in a dreadful state where he's having to wash his clothes in the toilet in his room. He has to sometimes, if he's in the library, because there is a 3-person hold that needs him to be moved from the library back to his cell. He has to sometimes soil himself in the library because he needs to use the loo. So these are the kinds of things that are worth keeping in mind. On the US side, their key arguments were that this is not a politically motivated prosecution because both the Trump and Biden administrations have both pursued it. They talked about how they talked about the Extradition Act, and that's on behalf of the Secretary of State of the Home Department, as well as on behalf of the US. They talked about how this intentionally at the moment excludes the protection for political opinions, which is present in the US-UK extradition treaty. There was a lot of discussion, which was quite surreal, about Chelsea Manning not being a whistleblower and Julian Assange not being a publisher. So these were the thrust of the US arguments. I'll now like to bring my contribution to a close and introduce our next speaker, my colleague and Professor Mads Andenæs, who's a professor at the University of Oslo. He was the UN President Rapporteur for Arbitrary Detention from 2009 to 2015. He was also the director of the British Institute of International and Comparative Law for many years. And in 2019, he was made a QC, now KC, and he's referred to as a stellar academic. Mats and I have known each other for a number of years, and it is a real pleasure to welcome you here, Mats. Thank you so much for making the time to be on the panel and to share your thoughts. We look forward to hearing from you.
Very many thanks, Deepa. So Julian Assange has been in detention since 2010. That's 13 years. And the whole detention has been a travesty. Authorities have pierced together these legal bases for keeping him in detention from the first detention period he had in 2010 when he was in high security detention, his first period. And then until today, where he's now had so many unnecessary years in high security detention, which is a very testing existence, and it is not any surprise in him being worn out, worn down, and in a very parlous, in a very bad health. Now, I got involved while I was the UN President Rapporteur of this United Nations Working Group on Arbitrary Detention, and Julian Assange's lawyers made an application to the working group. This is a working group this is a body which receives individual complaints, which is appointed by the UN Human Rights Council, which is the third most senior body in the United Nations system. And it consists of experts on detention, on international law, on human rights law. And the presidents before me had been judges in different countries in the world. A French Supreme Court Justice, a Tunisian Supreme Court Justice, and a Senegalese Supreme Court Justice, and there was I. We got this case in, and it was actually formally decided just after I left my office. And the working group then said in its ruling that the detention of Julian Assange from this first high security detention was arbitrary, back to 2010. And they said, the working group said, that it was disproportionate to put him into this high security regime. How could that be justified? It's obvious that it can't be justified. It's just like the high security detention he's under, he's suffering today. Disproportionate. And then he was in a situation where he got out for a short period on bail, and there was a judgment after the appeals process had run out against him for extradition to Sweden on the most flimsy of investigative steps. There was no formal charge in Sweden at this stage, although they had this extradition request, the status of which was dubious in itself. But just to give it a picture of a whole set of very contested and dubious government actions at different stages. The working group then held that there wasn't any grounds which were sufficient to merit an extradition request from Sweden. The extradition request did not merit an extradition from the UK to Sweden. So in both those cases, the case against Sweden and the case against the United Kingdom, there was a violation of international human rights standards. And the working group said this applied, just looking at the procedural steps taken in the criminal case and extradition case. But on top of that came that you were here at the core of the freedom of expression. And Marjorie mentioned that the US authorities had stated that the freedom of expression protection didn't apply. The First Amendment in the US to the US Constitution did not apply to Julian Assange because he's not a US citizen, and whether that will hold up or not is another matter. But the point is that he's most clearly subject to the protection from and should benefit from the protection of the right to express himself and to exercise those rights as he is in the UK. And one core element when you're looking at the freedom of expression, which all courts dealing with freedom of expression is taking extremely serious, is the chilling effect. When you subject somebody to a legal prosecution of any kind, a criminal prosecution in particular, that has a chilling effect on others who want to exercise their freedom of expression. 13 years, that's my starting point. In detention since 2010. This is so obviously having an enormous chilling effect. Now, you look at the enormity in a positive sense of what Julian Assange has achieved. The publication of all these extremely important material, which showed up a series of war crimes and other offenses. Well, first on the private side, of course, he starts with many private actors, but when he gets into this core of the US authorities and the waging of war in Iraq, well, obviously, this is of extreme importance to our democracy and our political system and our legal system. Now, that enormity in a positive sense has, of course, led to this other enormity in a negative sense, the persecution of Julian Assange. And then to go back to the way the United Nations has dealt with this. So it's the working group, which I chaired for a period. And then there are a number of other special rapporteurs on torture, on freedom of expression, of course, on human rights defenders, who all have held unconditionally that the persecution of Julian Assange is in violation of international law. And then around this working group decision in 2015, which is the first, which all these later UN bodies or UN officers then refer to and strengthen in their later work. Who is that? Who are these people who sit there? Well, they are the specialists on, say, arbitrary detention for that body, on torture, on human rights defenders, on freedom of expression, chosen by the different countries which sit in the Human Rights Council. They are the foremost experts in their field. Are their rulings binding? Well, in a formal sense, they're not binding, but they are pretty authoritative on the question of international law. There are no more authoritative bodies than these on the international law questions we are dealing with here. And of course, if this had been a question of an arrest, a detention in Russia, torture conditions in Russia, a human rights defender in Russia, in Iran, or in any other country in the world which we are not closely associated with or allied with, our authorities, our politicians would have used these authorities for all it's worth. And of course, it's only when there is such a highly politically focused case where there's so much at stake for certain authorities, where one so completely rejects the authority of the UN. Now, does this have any impact on a domestic case? Yes, of course it does, because the international law provisions we're talking about here in the International Covenant on Civil and Political Rights, the Torture Convention and other UN conventions, they are very parallel to the provisions you find in the European Convention on Human Rights, which is given direct effect as law, as domestic law in the UK and in all the other Council of Europe states. So the idea that this is not law, what is stated by these UN bodies, is completely wrong. And the UK courts, here the English courts, have a duty to apply that international law, that human rights law, the European Convention on human rights. Now, there are many other issues relating to the judicial proceedings. First of all, the first important decision, the 2010 UK Supreme Court decision, was there was a majority and a minority. 2 judges dissented, and they held that Julian Assange should not be extradited to Sweden, which was the question then. The 2 dissenting judges were Baroness Hale, who later became president of the UK Supreme Court, and Lord Mance, who later became the vice president of the UK Supreme Court. As we know later on, we have a district judge who then ruled in these later rounds where there was an extradition request, not from Sweden, as in the first round, but from the US. Then the district judge then ruled that due to the threat to his health and life, he could not be extradited to the US. She was overturned on appeal, and that is, of course, the case. We now have a different, a final or another round of then in front of the English courts, and it may end up then in the Supreme Court. This previous round, where there was an extradition request to Sweden, that now seems to be a bit of a farce, a made-up case, which does not stand up to the review which we now can subject it to. At the time, also in the UK Supreme Court, Assange's lawyers said, well, this is actually just something which is there to prepare an extradition to the US. And Julian Assange said so. And if you had spoken with many of the people who covered the case, many of the lawyers who were involved on the other side, they would said, this is paranoia. Here we have a request from Sweden, which frankly is about, simply is about some sexual offenses. He hasn't been charged yet. There's no formal steps. There's some very, very informal investigatory steps. And they have this, in that context, they have this extradition request, and we're bound then to follow that. That was also subject to review in Sweden. And an early round of that ended up in 2015 before the Swedish Supreme Court. And the Swedish Supreme Court divided like the UK Supreme Court had done. And the preparing judge under the Swedish system, she then wrote a preparatory opinion where she said it was disproportionate. He shouldn't be extradited under Swedish law. And then in the Supreme Court itself, one of the judges dissented. Now, a couple of years later, the case comes up again as a new extradition request before Uppsala City Court. And the judge there, she then says, she throws out the request and says, this is disproportionate. It doesn't carry the request. So the Swedish case ended, and shortly afterwards, also the prosecution then gave up all claims, in addition to there being a statute of limitation, which meant that under Swedish law, no claims, no prosecution could be brought against him on the charges they had been considering for so long, for some 10 years. Now, the way these charges are brought now under the Espionage Act is another chapter, and you will have read about this, and I'm not going to add anything to that discussion. I just wanted to bring up these 3 or 4 different perspectives. First of all, to sum up, 13 years of detention. Now, you may say, but he was in an embassy, in asylum for a period. That was not being in detention. Well, I visited him twice after I had left my UN office, and that most certainly was detention. That was a very unsatisfactory way of living, extremely circumscribed, no fresh air, no way to get out, and under extreme surveillance. The UN Working Group on Arbitrary Detentions explained it in their opinion. If he had stepped into the street the moment he had stepped into the street, he would have been taken into the same kind of high security detention he had been in 2010. That meant that this constituted a detention, that he then had not reported himself at the end of his bail, but instead had gone to the embassy, or something the UN Working Group on Arbitrary Detention said he was entitled to do to avoid a new period of arbitrary detention. So that's the 13 years. Then you have the travesty of these legal processes. First, they tried to get him to Sweden, and now they try to get him to the US. And the charges, or the previous very preliminary investigatory steps in Sweden, which didn't constitute a charge under Swedish law, they were all, spurious. And to link together in a legal process on such thin grounds, something which then adds up to 13 years in detention. Well, if you look at that from a freedom of expression perspective, well, then you have a chilling effect. Who would today, with the consequences for themselves and their families and everybody who's involved, be able to take a step like Julian Assange did? At least the price is so enormous that it most certainly will have a chilling effect. So then you can say, if the case had ended here, the people in the security apparatuses in the US and in the UK, in Sweden, and all the countries which have been involved here, they have achieved their goal. That's very sad. They have achieved their goal. And we must make sure and really hope that this ends here, in the sense that the case rests, that Julian Assange can stay in the UK or travel to Australia as he likes, as he wishes to, and we were able to welcome him in our different countries in a very short time. The travesty must end, and it must end here.
Thank you, Mats. Thank you very much for that contribution. I hope everyone can see me again. I might have to make sure that Mats is... there we go. I'd like to now invite a very, very special speaker to the stage. Mahamadou Ould Slahi is a writer and political prisoner. Mahamadou is spent 15 years at Guantanamo without trial or charge. And during that time, he wrote some beautiful books explaining the relationship, for example, with the prison, and thereafter the relationship subsequently with his prison guard. Mahamadou also writes poetry, and he has very kindly agreed to come and speak to us today and read some of his poetry. So we'll spend a few minutes doing that and then go into question and answers. We are expecting to close this call in about 20 minutes after questions. So Mahamadou, over to you. I hope you're able to unmute yourself. Okay. Mahamadou, can you hear us?
Yes, I can hear you very well.
Thank you.
Thank you so much, Deepa, for inviting me. I really feel very humble to be in this beautiful gathering with my co-panelist and my good friend Deepa and Mads. And I never met Mads or Marjorie or Thomas or Jeren, but I heard so much about the work. And we say in Mauritania, don't ask about the person, ask about the people around that person. And I think I already have this connection with all of you because of the beautiful connection I have with my good friend Deepa. For those who don't know me, my name is Mohammed Al-Salahi. After the horrific events of 9/11, two police agents from the Mukhabarat, the secret police, came to our house. I was alone with my mother, and they asked me to come with them. They did not show me any reason for my arrest. Later on, I learned this was based on marching orders coming from the United States of America that I should be arrested and kidnapped. To this day, I would never ever forget the image of my mother as she held her prayer beads, as she prayed frantically, and she was shaking as she disappeared when the police car pulled away. I never saw my mother again. I never saw my brother. Both of them died. I'm saying this because I want the people on this panel who are not from my part of the world, i.e. Africa and the Middle East, to understand that we are exposed to these systems of oppression, to be perfectly honest, colonialism with no filter. There is no filter between us and the violence of the surveillance system, colonial system. And I always remember these beautiful words from the late Reverend Niemöller, the German Reverend Niemöller, who said, first they came for the socialists. And I did not speak out because I wasn't a socialist. And they came for the unionists. I did not speak out because I wasn't a unionist. Then they came for the Jews. I did not speak out because I wasn't a Jew. Then they came for me, but there was no one left to speak for me. This is the story of Julian Assange. And, you know, when I hear, you know, I mean, he is really very eloquent when he speaks, but when I heard those people, you know, like enjoying the killing of those innocent people, like in a video game, you actually use these video games. And then I never forget this sentence, you're clear. After he shot all those people, he told them in the radio, you're clear. But Julian Assange is not clear. And when everything I read and I saw about what Deepa qualified as war crimes, the only people who were punished since the invasion of Afghanistan and Iraq were the whistleblowers, or the people who exposed those crimes. I'm not aware, and I stand corrected, that anyone who was involved in the torture, including to death, was brought to trial. I spent 15 years in prison, and I was the first death penalty case. And I can never forget the day when First Sergeant came to me and was explaining to me how they are going to kill me. And this was like so surreal. And I had no feeling, absolutely no feeling, like knowing in the heart of my heart that I didn't do anything, you know, and that they were going to kill me is something so surreal that I cannot put in words. And you may defend Julian Assange, you may not defend him. You may defend people like me, people from Africa. But one thing is sure, those are your first line of defense. If you don't defend them, they will come for you sooner or later. And since I promised to read a poem, after the election in this beautiful country, the Netherlands, so we have the strongest party is extreme right. And I was very upset because I really love this country because it gave me a place to stay and I work in it. And I didn't know what to do. And then I was just walking, and then this poem came to me. We say in Arabic, I say a poem. We don't say I wrote a poem. We say I say a poem. قلت شعرا. The poem is, I'm not going anywhere. I want you to be aware, I'm not going anywhere. I might be deemed lazy, or you may think I'm crazy, but I want you to be aware, I'm not going anywhere. Because I love this country, the people, the land, and the boulders. I'm sticking around. I'm not going anywhere, as you may stick around. But I want you to be aware, I'm not going anywhere. You say the house is full. Every place is taken. I found my place. I'm not mistaken. My faith is like Arak, and I'm not shaken. So I want you to be aware, I'm not going anywhere. Not now, not tomorrow, not in a million years. It is mine as it is yours. So I will shout, and I will repeat through my windows and through the doors, I want you to be aware, I'm not going anywhere. Thank you so much, and send you all my love.
Thank you, Mohamedou. Thank you for sharing that with us, and huge round of applause from all of us. On that beautiful note, we will now open the floor to about 15 minutes of questions. So please do raise your hand. I will promote you to panelist status so you can be seen and heard. If you don't want to be seen and heard, you can put your question now in the Q&A chat, and we can take that. I have a question from Rick Peltz Steele first. So if I may, I'm going to invite Rick to join the meeting room and then speak. So I'm going to promote you to panelist. Rick, you'll leave the room briefly and then rejoin as a panelist. So over to you next. Rick, can you hear us? Are you
I
able to?
can now. I'm sorry, Deepa.
No problem.
I just asked, and forgive my ignorance on this, please. I'm a professor at University of Massachusetts Law School, and I just wanted to understand the two-judge structure of the High Court. You all probably realize we use odd-numbered panels in the States, and I just wanted to
It's a very
understand.
simple thing. It's a very
Yeah.
simple thing. So
Thank you.
the High Court sits with 2 or 3 judges in certain cases, and so does the Court of Appeal. And if there's overturning anything, they have to agree. So that's how they do it. So if there's an equal number, they can't overturn what came from the lower, or they can't deny or grant according to rules which have been set already. So that's how it works.
Thank you.
Thanks, Matt. Thanks, Rick. I can't see any other hands up, but I'm not sure if the hands up function is working. So if you have a question, please would you raise your hand? Okay, thank you. Joris de Draak, I think. I hope I've pronounced your name correctly. You're next. I'm going to try and promote you to the panel. I would be grateful if the admin please would, Liam, if you could please move Joris to the room if that's possible. Thank you. He would be at the top of the list. He or she would be at the top of the list. And Rick, in the meanwhile, I'm going to move you back to the audience. I think I have promoted you, Joris, and you should accept the invitation so you can rejoin as a panelist and ask your question. Joris, please accept the invitation which is showing on your
Or
screen.
just put it in the
Or you can put it in the chat.
in the
That's
chat.
easier.
It's the
I al-
easiest.
I also have a question from Flavia, which I'm going to promote you already, Flavia. So please join and keep yourself muted so that you can ask. Joris, if you will unmute yourself and ask your question, please. Thank you. And you're welcome to introduce yourself.
I'm here in,
Hello.
hi. It apparently it well appears on the other screen. The question I have is the trial of Julian Assange. Has it already been held, or is it due tomorrow? And if it has been held, what has been decided?
So what is being tried now, yesterday and today, hearing today and yesterday, is the question of whether he's allowed an appeal. So that's the question, and then that's a preliminary question. If leave to appeal is granted, then there will be a full hearing on the appeal. So now it's a very narrow preliminary stage ruling, which is about should he be allowed to appeal.
I have
Yeah,
That's Marjorie, please do come in. Just Joris, if you wouldn't mind, I'll bring Marjorie in and then you can ask your supplementary question.
Yes, yours. There was an extradition hearing. I believe it lasted for 5 days before the district court judge in the UK. That was in September of 2020. That's when it ended. And she made a ruling in January of 2021 denying extradition because he was a suicide risk if he were sent to the United States and held in egregious conditions. And during that 5-day hearing, there was a great deal of evidence and testimony that was presented. So that was like a trial. It was a hearing. And then there have been a series of appeals. And as Mads said, we are now at the stage where Julian Assange is asking the High Court, the 2 judges on the High Court, for permission to be allowed to raise appeals issues that they say that the district court judge did not fully consider.
But the substantive issues, the charge against him has never been tried. The only thing which has been tried and in different stages in Swedish courts and in English and then the UK court, the Supreme Court of the United Kingdom, that's only the question of should he be extradited first to Sweden and then afterwards now to the US. That's all. And that's then taking endless time. And that's my travesty point. You can't keep a person in detention for 13 years for this. That's just disproportionate, period.
That's disproportionate. I fully agree. But there is a trial or there is a decision today or tomorrow.
Could I come back on that actually?
That'll take its time because they ask for written submissions, so that when that comes is a bit up in the air. That's for the judges to see whether the material, to assess the material and then write an opinion. That'll take its time.
Okay, but as
So
far as I understood,
if you don't mind, I will take another question. Did you have a final point you wanted to make before we take the next question?
yeah, obviously, because my question wasn't answered. I want to know these days, today, tomorrow, or the day after, there is some kind of hearing in High Court in London.
Could I respond to that?
Yeah.
I'm sorry, I think it might have gotten lost while 2 of us were speaking at the same time. For the last 2 days, there have been two days of hearings that have already taken place. So today was the 2nd day. And what Mats was trying to explain was that the judges have requested some more information, which will be given in writing. And that the deadline for that is somewhere around the 4th of March, which is, so we don't expect any decision for a little while now. The judges have reserved the judgment and they will let us know when the judgment is available. So we do not have an answer yet. I hope that answers your question.
Early March.
No, there is
Late
no
March,
date
April.
at this stage. We
April.
never know, because in the past they have taken between 6 and 9 months sometimes to come back and opine on things. So we never know how long they will take and what that will be. But if you don't mind, Joris, I'm going to take the next question because Claudia
sure.
has been
But
waiting very
bottom
patiently.
line is Julian Assange will still be in Belmarsh.
Yes, and there was no application made at this stage to release him from Belmarsh. It was simply a permissions hearing to ask if he can appeal the lower court judgment. So that was where we were.
Yeah, good.
Our next question is from Flavia Donati. Flavia has been involved along with other grassroots supporters, I'm aware, in Rome. If you could say a word or two about the recent citizenship for Julian in Rome, and then ask your question, Flavia.
Yes, can you hear me?
Yes, very clearly. Please go ahead.
Yes, after a very long process, Rome, which is Italy's capital, granted the honorary citizenship to Julian Assange just last week. And along with Rome, other cities have done so, like Naples, Bologna, other cities. And it's a process that is going on, you know, but anyway, the fact that the capital granted this honorary citizenship was very important to us. About the hearing, I could only follow this afternoon through the messages that were coming out from the team, Stella's team. And I was struck by a point that was made by the defense that seemed to me very important, that the United States cannot guarantee that no more charges will be added in case. And in that case, that the death penalty might be risked. Now, in Italian legislations, we are not allowed to extradite anybody to a country which has a death penalty, where the death penalty could be asked or risked by the prisoner. Wouldn't that be a very strong argument that the defense used today?
Thank you. They did use it, but I think it would be good if we had brought in either Martz or Marjorie if they want to comment on this. Martz, you might be more close to this.
Marjorie spoke about it in her introduction. They made all kinds of undertakings, which then the UK side, the English side, considered to be satisfactory. But as Marjorie said, they are written in sand and can be revoked.
Also, they have, sorry, I spoke over you, Marjorie. I just wanted to say that they have, one of the things that the defense team reiterated in court several times is they have given no assurances about such changes affecting the death penalty, and they have had plenty of opportunity to do so. So the death penalty is still very much on the table. Over to you, Marjorie, please.
Yes, I was denied remote access to the two-day hearing because I am not physically present in the UK. But from reports I've read from those hearings, apparently at least one of the judges was quite interested in the point that the US government could add the death penalty later under this very loose extradition treaty. So yes, that is a concern. Hopefully that will resonate with both of these judges, and we will get a positive ruling allowing Julian Assange to fully perfect his appeal in the High Court.
So, thanks, Marjorie. And I just wanted to add a small thing to that, which is it is not even the whole of the UK that has remote access. It's only those in England and Wales, which is the jurisdiction of the court. So if you're in Scotland or Northern Ireland, you don't count. So it's worth flagging that. On that note, I have one final question. What is to come next in the trial procedure once the decision is made about the whether there is permission to appeal? Then it will be decided how many grounds are allowed. And depending on how many grounds are allowed. If there is no grounds allowed, then there is a possibility that Julian, of course, there is the next option is to go to the European Court of Human Rights in Strasbourg. And if not, if Julian is not permitted to, if the UK doesn't respect those requirements, then he could be on a plane to the US, which is what the discussions from the family were about. But as far as we're aware, the UK has never disrespected an interim order from the Strasbourg court, and it would be expected that Julian's next recourse is at the European Court of Human Rights, were he to not get permission to appeal. If he gets permission to appeal, then depending on the number of grounds, it will be litigated again in the UK. Mats, did you want to add to that, or Marjorie?
I'm not sure if it's so much to add. I think it was a very good answer. The point is that the courts, when they're deciding, when they have this appeals procedure where you have to get leave to appeal, they decide what are the grounds on which you can appeal, and then that goes forward, and that's what we hope in this case. And I think that would probably be, well, we don't know how they're going to limit the appeal or what grounds they're going to allow it, if they are going to allow it, but that's what we hope for. If not, the next stage then is, as you say, the European Court of Human Rights, and then there's the question of interim measures, because the European Court of Human Rights takes its time to decide a complaint. So the question then is, can they send him away in the meantime? And then in order to stop the UK authorities from sending him to the US while the case is pending before the European Human Rights Court, one has to get the court to grant an interim order. And hopefully that would work out, but there's no guarantees for anything at this stage.
Thanks, Mats. And any final comments, Marjorie, before I hand over to Jaren to bring us to a close? Marjorie, any
Just
final
one brief addition to what Mads said, and that is that one of those interim orders that could come from the European Court of Human Rights could be an injunction preventing the UK from extraditing Julian Assange to the United States during the pendency of the appeal in the European Court of Human Rights.
Thanks, Marjorie. I can't see any further questions, so I'm going to stick to time and bring in our final contributor, the Co-Secretary General of the European Lawyers for Democracy and World Human Rights, who are hosting this event, and we're very grateful for the work that you do and all the different progressive lawyers associations do to further the rule of law. Over to you, Jaren.
Thank you, Deepa. Greetings, everyone, and once again, I would like to thank you on behalf of ELDH. I think today we had a quite fruitful discussion about the Assange case, but I want to take a moment to reflect not just on the specifics of this particular case and situation, but as some of our other panelists mentioned, I think we need a kind of a broader perspective here, especially about our common values, justice, freedom of speech, and human rights, which are directly related to this case. So this means that in ELDH, we do not consider the Assange case just about one individual, but we believe that this case itself speaks about the fundamental principles that underpin our societies. It's about the right to free speech. It's about the right to a fair trial, and it's about our responsibility to prevent arbitrary detention and torture. And we all know that these are not principles. These are not just abstract principles, but they are kind of the bedrock of any democratic societies. And as it was mentioned today, the violations we observed in last 13 years in this case, let's say, it sends a powerful signal to the rest of the world. Such violations are encouraging, let's say, the other states that are clearly turned their face to authoritarianism, like Turkey, Russia, and many others. And also, I think, which I think this is very important. This case reminds us that no country is immune to the pressures that can lead to the erosion of rights and liberties. But today, when I am closing this discussion, I want to say that this also gives us or reminds us our responsibility to unite our fight against this situation, against this attacks against our fundamental rights. But after listening to Muhammadu, what he said, I also wanted to raise some other issues here, maybe. You know, time to time in Europe, it is so easy to identify the issues in other countries. When it comes to Turkey, when it comes to Russia, when it's come to Iran, you know, we can speak about them. We can criticize them. We can protest them. You know, this is the way how even the regulations in Europe are talking about these countries. You know, they are the third countries in a very subjective way, in a very discriminative way. So, of course, we can protest them. Of course, we can criticize their governments. But when it comes to Europe, in my opinion, it always takes time to accept the reality. And I suggest today accepting the Assange case as the reality of the world we live in. I hope that this case will help us at least to awaken from the illusion of European democracy, but be more aware of the realities we are living in and to stand up against them. So here, maybe this is a good time or good opportunity for me to mention one thing. 4 years ago, in 2020, there was another political prisoner in Turkey, Ebru Timtik, who died after a 280 days long hunger strike in prison when she was demanding fair trial for all the other political prisoners in Turkey. And together with the LDH, more than 20 other legal organizations and rights organizations came together and we established an International Fair Trial Day and Ebru Timtik Award. In this day, every year we are trying to focus on one country, one particular country that has systematic violations of fair trial. And also we are trying to connect different actors of the rights, of the fight for human rights, like not just the lawyers, but journalists. We are coming together with journalists. We are coming together with artists, poets, etc. So I hope that in the future, we will be able to come together with the people who are here today for doing more and for doing this in a quite equal way. You know, I hope that we will also open our eyes to the problems that we are facing inside this continent, you know, and I also think that supporting the case of Assange should also mean that supporting the refugees in Europe, supporting the victims of torture all around the world, supporting every single person, every single political prisoner around the world. And I hope that we have an amazing opportunity to do this. We will go on organizing this webinar series thanks to Deepa, because we believe that there are different aspects of the Assange case for us that is necessary to discuss in detail. Thank you once again, and hope to see you soon.
Thanks, everybody. I'm going to stop recording. Thank you. And I'm going to end the call. Thanks, everyone, for being here. Bye. Thank you to our speakers, of course.